Hello, my name is Dean Contover, and this is Current Buzz. Thank you for watching today. Today we have attorney Jeffrey Higgins. He's an elder law attorney, so you can get a piece of paper and pencil out a pen and take down the information because it's very important. Some things that you should know now and some things that you should know later. Am I right?
Absolutely.
What is elder law? I mean, why did you get into it? How did that happen? And
Well, I got out of law school. I got hired by a great man by the name of Jim Doyle. He hired me, and that's what he did. He did elder law and criminal defense, and so he taught me everything about elder law, and more importantly, he specialized in protecting assets for people in nursing homes. If people are concerned about going in a nursing home and losing their house and their cash, he protected them, and he taught me everything I needed to know about that, and then I went out on my own, and I've been on my own for 26 years.
now, where is your office?
It's at 227 Chelmsford Street in Chelmsford, right on Route 110, over by the Kohl's department store. And I've been in that building now for 26 years in April.
Wow.
Yep, 26 years.
Wow, that's good. So, elder law, do they call you or somebody refers
Yes.
them to you? How does that happen in regards to your name and?
When I first went on my own, I was struggling.
Yeah,
for a young
that's
lawyer
usually.
and hard to get clients.
Yeah.
But I struggled along. But now at 26 years, I get a lot of referrals from my clients. So I did a will for somebody 15 years ago,
Okay.
and they send their neighbors, their relatives. So it's a lot of referrals. And, and then I have my website, and I have an ad in the Lowell Sun every day. And,
Oh, you do every day?
Every day I have an ad, and it's been, a good ad.
I don't remember seeing that, but
The ad says,
I guess I don't read the Lowell Sun enough.
it says, protect your home and assets from the nursing home.
Okay.
That's what I specialize in, is I do all elder law.
Right.
But a lot of people don't know that there are elder law attorneys that do estate planning and probating estates and
Right.
drafting wills, but they don't have that extra piece of Medicaid law. They're federal laws, and those laws apply if somebody has to go to a nursing home.
Okay. I'd like to talk to you about Medicaid, but first I want to talk to you about wills and trusts.
Yes.
Okay. So
So-
I come to you.
Yep.
I say, I want a will, all right? And you make up a will.
Correct.
Right.
I draft a will, you sign it in front of two witnesses, and I notarize it, and you have your will. But the problem is, a lot of people think, I got a will, I'm all set. That's all I need. I need a will. No. A will has to go to court. And a lot of people don't understand that. They think, oh, I got a will, it says my house goes to my kids, they'll get it when I die, no problem. No. The will has to go to court and go through what's called probate of your estate. So the will has to be filed, you have to pay a filing fee, you have to publish in the newspaper, that costs a lot of money, and you got to pay the lawyer a lot of money to probate it. Creditors have 1 year to file claims against your estate.
Oh, wow.
So your kids don't even get your assets till after the 1 year is up. So the will, you need it, but you really want to have your assets, like your house, in a trust, because the trust, unlike the will, avoids probate. So when you die,
I see.
your kids get all your assets, no probate, no lawyers, no creditors. Creditors can't file claims. So very important that you have a will, but you should really have a trust.
And a trust does what?
So if you put your house in trust, you still own it, still your house, nothing changes, just the name, instead of Joe Smith as the owner, it's Joe Smith trustee. And when you die, there's a successor trustee, maybe your child or whoever you're leaving your assets to, and that avoids probate. So when you die, the successor, say your son, your daughter, your whatever, whoever your heirs are, they take over and they own it immediately. No legal fee, no probate, no creditors. So they can put your house, oh, I want to sell Dad's house, next day on the market. Yeah, so the trust is very important. It avoids probate, and then there's also a trust that protects from the nursing home. So if you put your house in the trust, you stay out of a nursing home for 5 years, there's a 5-year look back, your house after 5 years would be protected if you ever ended up in a nursing home. They couldn't take it.
Now, a car is considered an asset, right?
Yes.
So would that block the family, the son from or daughter from getting the car?
Yes, absolutely. The car would have to go to probate.
You're kidding me.
Nope.
So that, I mean, you lose a year on that or two.
Well, there's a shorter. If your estate is under 25,000, so if you have just a car and maybe a few dollars in the bank, you can do what's called a voluntary probate or a voluntary statement. That's a real short version, takes a few weeks, and you'll have access to the car. I find that, a lot of times when you have people that are older, and like I had a client that he was in his 90s, and he had a Cadillac that had like 8,000 miles on it, and he wanted it to go to his goddaughter. I had him sign the back of the title, sign it over to her.
Oh.
And then when he passed, that I gave to the goddaughter, and she was able to go down and register it because he had signed it before he passed.
Oh, wow, okay.
So
A good question. So would it behoove me to have my name on my mother's car, or my daughter having her name on my car?
Sure, absolutely. That avoids probate.
On the, what would you call that? The
title.
The title.
Yep.
Because a lot of people don't realize that's property.
Yeah, absolutely.
And there's a title involved here.
Yep.
And get that title. Even though it costs $50 to change the name, it behooves let's say someone is married and he gets into some situation or has cancer or something like that and passes away, both spouses should be on the name of the car. Is that right?
Yes, that would avoid probate.
That would avoid probate. Okay.
It's not for when you're in your 60s or 70s, but when you're 80s or 90 and this may be your last car, you can sign it over to avoid probate. And that's what I did with this client of mine. He was concerned, he wanted it to go to the goddaughter.
Yeah.
So we signed it over right in his living room. And I told him, put it in a safe spot so that, when you die, somebody can locate it in the family.
Right.
And he put it in his sock drawer underneath the socks.
Well, I mean, so in other words, I could do that with my car for my daughter and sell it to her for $1.
Usually you would just sign it, and then you say, this is where I keep my title to my car. When I die, you fill it out, put your name in, and you'll be all set to go.
I see.
I
see. Okay, good. All right. I know we got a lot of things to do. Another thing is the power of attorney. How important is that?
Very important.
Very
One of the most important documents is the power of attorney, because if you get sick and you end up in the hospital and you're not competent, you can't pay your bills, you can't make decisions for a period of time, a power of attorney would give your agent the right to make all financial decisions. So if you're married, each of the husband and wife both have a power of attorney, and they're each other's agent.
I see.
And so if your husband goes to the hospital, ends up in a nursing home, and he's not coming home, and you say, well, I want to sell the house, right? Because it's too much for me to do with myself, to upkeep, the yard work. I want to sell it, I'm going to buy a condo. You'd think you'd be able to sell your own house. But no, your husband has to sign. And if you don't have the authority under a power of attorney to sign his name, you'd have to go to court and become your own husband's conservator. And now the court's involved, and $3,000, $4,000, $5,000 later, you'll be able to sell your house.
I see.
So the power of attorney is really, really important, just in case something happens to you and you can't make financial decisions. Sometimes it's only a short period of time. Sometimes it's permanent. So you should have a will, just in case. If you don't have a trust, you should have a trust. You should have the power of attorney.
Right.
And then the third document, the basic third document, is the healthcare proxy.
Healthcare proxy, okay. Yeah.
Somebody to make decisions. If you're not competent to make a decision on your healthcare, so you're in the hospital, you're in the emergency room, and the doctor says, hey, Jeff, we need to put a stent in your heart, you got a blockage. I make the decision, right? Because me. But if I'm unconscious, then my health care agent will say, yes, doctor, go ahead and go ahead, you have my permission to do that surgery.
I'll tell you an incident. What happened to me is my daughter was going to college and COVID broke out, and I said to her, I think we should sign a health care proxy because you're over 18 now, and I won't have a say. We had a discussion about it, and she understood and had got the witnesses to sign the proxy, and
Excellent, excellent idea. I mean, that's a great example of when you need it. You know, your child just turned 18, they're going off to college. If something happens and they end up in the hospital and they can't make their own decision, you know, mom or dad should be the agent
I
making
agree.
the decision.
Yeah.
Otherwise, you know who makes the decision? The doctor. And
right.
so,
or the school.
Well, maybe the school. I don't know, but
well, I
yeah.
mean, they might have physicians.
Yeah,
there.
yeah,
That would
absolutely.
make- yeah.
So you want to have, that's a great idea to get that healthcare proxy when the kids go off to college, just in case something happens. You never know what's going to happen in life. We can't look into a crystal ball. So
Right.
I think that's a great idea. And I just had a client come in, and her daughter was headed off to college. She did all her estate planning, and she said to me, hey, should I have a healthcare proxy? My daughter's going to college. And I said, yes. And I said, I'll do it for free because I'm doing all your work. So I'll do that one for free because, you know.
Yeah.
You know,
Well, it makes sense.
Very important.
So if your children are going to college and are over 18 years old, they're no longer minors,
Right.
And they're considered adults in the legal
Absolutely.
world.
Absolutely.
So it behooves you to get a healthcare proxy. I would suggest that as soon as possible, and explain it to your children why that should
Absolutely.
happen. Right?
Absolutely.
So, the power of attorney. The question I have is, ends when somebody's deceased, right?
Correct. Right. So that's why it's important to have that trust in place, because even if you have that power of attorney and you're in the nursing home or in the hospital and you don't have long to live, they can make decisions financially while you're alive. But as soon as you die, the power of attorney dies.
Okay.
And now we're talking either a successor trustee or, if it's the will, probate.
So what should be in the trust? What's the basic stuff in
Everything.
the trust?
So you know, typically if we do a trust, we're putting the house in it, we're putting the cash in it, and a revocable trust, you know, let's say it's a married couple, they put their house and their bank accounts in. When one dies, the other one still maintains control of all the assets. When the second one dies, it goes to the successor trustee who takes over and then disperses to the heirs. So if we have a typical.
What about a family of children of 5 or something like
Correct.
that?
So typically that would be a fifth to fifth. You know.
Yeah.
Each child would get a fifth.
Supposedly.
Right. And then it's more important if you don't have children, right? Because if you don't have children and you don't have any estate planning done and you die, guess who decides who's getting your assets?
The state.
The state. There's a statute that says, all right, if you die and you have children, they get it. If you have no children, guess who gets it next? Your parents. What if your father or mother are in the nursing home and you die in an accident? They're going to get your assets, and then the nursing home's going to get them. So if you have no children, first it's children, then spouse, and if you have no spouse, no children, then it goes up to your parents. If you have no parents, then it goes to your brothers and sisters. If you have no brothers and sisters, your nieces and nephews. You know, I had a client come in, had nothing done, and he's like, I'm single, I've never been married. And I said, well, your mom and dad alive? Nope. My brother, yeah, I haven't talked to my brother in 30 years. We never got along.
But he might get.
He'll get everything if
He'll
you
get
die
everything.
without a will
Right.
or a trust,
Wow.
right? So very important if you have no children to have a trust so that you can direct who's going to get your assets.
Some people live with people, but they're not married legally.
Right.
So that would be protect those particular people.
That's really a problem, because if you say you have a life partner that you've been together for 30 or 40 years,
Right, or even
but you're
10,
not married,
yes.
and you don't have your estate planning docs in place, and you die, they're out. They don't get anything.
They don't even go to the hospital. I mean,
Right,
you have to have a
right.
proxy too,
They
right?
don't even have any rights. To make healthcare decisions,
Right.
financial decisions. So really important for people that are not married to have them.
Right.
Single people, even, very important. Now, if you have a married couple and one of the husband or wife dies and you have nothing, well, the statute's going to direct all the assets to the wife and children.
Right.
So that's, okay, but sometimes people don't want to leave their assets to their children. I had a client, well, my son's a millionaire, I'm not going to leave him anything. I'm going to, because he doesn't need it.
Yeah.
So who knows? But, you don't want the state to decide. And more importantly, if you do any estate planning or, do any trust, if you get sick and end up in the nursing home, you could lose your house, your cash, and instead of the
let's talk about that.
Yeah.
Medicare and Medicaid. What's the difference? And you said you do Medicaid?
Yes, Medicaid.
Let's talk about
So Medicare is your health insurance.
Okay.
Just when you turn like 65, which I will turn next year.
And the federal government pays
Right.
into 100% Medicaid.
Right, and you have, you might have to pay in a certain amount to get your Medicare depending on your income. So that's just health insurance.
Okay.
That doesn't help you if you end up in a nursing home. If you
Okay.
end up in a nursing home, the Medicaid laws apply.
Okay, let's talk about that.
Right, so-
that's your expertise,
Yes,
right?
that's my expertise.
Okay.
So with a married couple,
Okay.
the rule is if let's pick on the husband. The husband ends up in the nursing home. The wife gets to keep one house, the house where you live. So if you have a vacation home on the beach in Maine, that's a countable asset that has to be used to pay for the nursing home, right? So
And
if
you sell it before you go to the nursing home,
well,
or give it to your child prior to.
you put it in an
Maine?
irrevocable trust
Irrevocable
to protect that house
I
in
see.
Maine.
I see.
So the wife gets to keep the marital home where she lives,
Right.
plus $154,000. That's $152,000 for the wife and $2,000 for the husband who's in the nursing home. So the total of $154,000 in cash. So that's the general rule. So if your husband has a 401k with a $400,000 in it,
Wow.
that's a countable asset that has to go to the nursing home. If you have the wife has a 401k that's got 200,000, she can't even keep that because that's over the asset limit, right? 154 is the total, and they don't care whose name the asset in. They just add up all the assets. So you got $1 million in cash in a house, keep the house, spend down the million. Once you get to 154,000, Medicaid will pick up the tab.
Should I spend it in jewelry and buy a car?
So what you can do as a married couple is you can utilize the trust for not only property, your house or your vacation home, but cash. Put in cash. I always say to my married clients, how much are you going to spend in your life? You're 75, you're retired, you got $1 million. How much are you going to spend? And they say, well, I want to keep $500,000 just in case I want to
Yeah.
do something. All right, we'll put the other $500,000 in the trust.
You could put it in the trust.
Yeah,
Now,
and that
who
will
would
be
who would
protected.
hold the $500,000? Would it be through a bank or something?
Well, right now, no. The trust we do now is that if we have a husband and wife and they're going to put their house and their cash in, they are called the donors. They're creating this trust.
Right.
I also make them the trustees, so they're still in control of everything.
I see.
Right? And the kids are only the beneficiaries, and you pick one of your children or whoever you trust to be the successor trustee. So when the husband and wife, when both have passed, the successor takes over and distributes the assets to the beneficiaries. But what the irrevocable trust does is if you put your house and that $500,000 into the irrevocable trust, after 5 years, bulletproof from the nursing home.
After 5 years, that's
after
the
5
big.
years.
That's
Right.
the big key.
That's the
Do
key.
this before
Right.
5 years. So you
Correct.
should do it in the 60s, 70s.
Yeah, when you retire, I think it's
Okay.
a good time to
I see.
get it started.
Make sure you pay off your mortgage before you retire, right?
You could do that.
Yeah.
So the key is with a married couple, the rules are very favorable. So even if you haven't done any planning and the husband goes in the nursing home and the wife, they have $1 million and a house, you still are able to do something to protect the excess, the over the 150, because the rules are very favorable.
Right.
It's not very good, but it can be done where you let's say your husband has a 401k for $500,000. He's allowed to gift that to the wife. The rules allow that.
Okay.
But what does he have
What,
to do?
in lump sum?
The whole thing could be gifted.
Okay.
But the problem is you have to pay the tax, right? Because you haven't paid. So that's $100,000 or more in taxes
Right.
that you have to pay. Then when the wife gets it, she's still over the asset limit. So then we can take anything over that asset limit and purchase what we call a Medicaid qualified annuity, which will give the wife a check. So what we're doing is converting the excess assets. Say they got $650,000. She's 500,000 over. Take that 500, buy a Medicaid annuity for the healthy spouse to give her income. So that'll give her a check every month for the rest of her life.
Oh, wow.
But now she got to keep it. Now, it's not great. The annuity is obviously not paying a lot of interest, but it's an emergency fix, because what we've done is we've lowered the assets under the asset limit, and we've upped the wife's income, and she can have as much income as she wants. So,
And the husband could get Medicaid.
and then he'll get Medicaid,
Medicaid.
instead of the wife having to pay $15,000 a month to Duville Manor. Medicaid will pick up the tab. So married couples, the rules allow you to do things to protect everything, even if you haven't done any planning. If you've done planning, even better. But the single person or the widow is a problem, because now there's no annuity you can purchase. There's nobody to give the assets to, like your spouse. So it's really important for people that are single or widowed to do the irrevocable trust to protect assets, because they don't have the same options as a married couple.
Now, if you have $500,000, you can give $15,000 as a gift, tax-free, right?
Tax-free.
It's still $15,000.
That's the IRS.
Okay.
But Medicaid is different. If you go in the nursing home and they say, well, we see you gave $15,000 to each child the last 4 years, those are all disqualifying transfers. So even though the IRS says you can give it to your children tax-free, Medicaid says you can't. It's a disqualifying transfer. That's why it's better, instead of giving $15,000 to each child every year, take a lump sum and put it in the trust. That gets the 5 years kicking on the entire amount, rather than every year you got a 5-year gift.
Yeah, I see.
You know what I mean?
Oh, good point.
Yep.
Good point. Yeah. I mean, there's a lot of things that you should know, and this is very important, you know, to
Absolutely.
pick up
I mean, you know, you've got to, the single people really need to do the advanced planning, or widowed. You know, I have clients, you know, husband died. Now they come in and say, hey, my husband's gone. He left me this 401k, he left me this. I want to protect it. Because with a single person, the asset limit's $2,000. So you don't get to keep your house.
That's crazy. $2,000 is nothing
$2,000.
these days.
Yep.
The legislature should jack that up.
Oh,
really.
yeah, absolutely.
What do you think they should jack it up to, 5 or 10?
Well, New Hampshire, they allow you to keep $2,500 as a single person.
Yeah.
But basically, you know, that's been the limit since I started 27 years ago doing this type of law. So it's never going to change, right? I mean, you know, they don't want to use taxpayers' money to pay. Now, you contribute to Medicaid out of your paycheck every week.
Right.
You know, you see Medicaid, right?
Right.
Well, that's just in case you need it.
Right.
In case you end up in a nursing home. So why not take advantage? So, you know, I specialize in protecting assets. So if you do something 5 years in advance, that's great. Everything's protected. If you don't, there's still things you can do. Even if you're single or married and somebody ends up in a nursing home, there's always a way to protect some of the assets.
You know, Jeff, we're going to have to come back, because there's a lot of questions I have on the list, and I knocked off half of them.
Yeah,
I've got
absolutely.
another group. But I have a minute and a half to go. What anything that you should suggest, or anything else?
I would suggest give me a call. I give a free
good point.
consultation. You know,
okay.
You can call me at 978-256-4704. I'm right in Chelmsford. I grew up in Bill Ricker. I've been here in Chelmsford, like I said, in this office 26 years.
Wow.
Come in, we talk. I tell you what I think you need. If you don't want to do anything, it's no charge. And if you want to do something, you have a price list, so you know exactly. Like a will is $200.
Okay.
You know, I see these ads on TV where they're saying, oh, you can do your own will online, and you can't afford it because the lawyers are charging so much. Oh my God, we only charge $199 for a will. That's
What about a trust? How much is?
Well, a trust is, you know, a couple $1,000. But the will, if you're just looking to do